Most people make critical mistakes in the first 24 hours after a car accident that can cost them thousands of dollars in compensation they'll never recover, and the insurance companies are counting on it. In this video, I'll show you the 5 most important steps to take after a car accident in Kentucky or Indiana so you can protect your rights, your health, and your financial recovery. I'm Karl Truman. As a retired United States Army officer and attorney for over 34 years, I've helped thousands of people across Kentucky and Indiana win fair compensation after serious injuries. If you or someone you love has been hurt, don't face the insurance companies alone. Call 502-222-2222 and count on the Colonel. Let's start with the moment of impact. You've just been in a car accident, your heart's racing. Maybe you're shaken up and you're trying to figure out what just happened. This is where most people make their first mistake. They either panic and do the wrong thing, or they assume everything's fine and make decisions that hurt their case later. Here are 5 steps you need to follow. Step 1, secure the scene. Call the police and document everything first. Do not leave the scene under any circumstances. Under Kentucky law, leaving the scene of an accident is a crime, even if you think the damage is minor. Turn on your hazard lights and check yourself and your passengers for injuries. If anyone is hurt, or if you have any doubt, call 911 immediately. Always call the police, no matter how minor the accident appears. In Kentucky, you're legally required to report any accident that causes injury, death, or property damage exceeding $500. The police report becomes one of the most important pieces of evidence in your claim. It documents everything: the date, the time, the location, parties involved, witness statements, and often includes the officer's opinion on who was at fault. Without it, you're stuck with a he said, she said situation, and the insurance companies will use that against you. While you're waiting for the police, start documenting everything with your phone. Take photos and videos of the vehicles involved from multiple angles, focusing on the damage. Photograph license plates, the surrounding area, any skid marks, traffic signs, road conditions, and weather conditions. Get contact information from any witnesses because their statements can be crucial if the other driver changes their story later. Exchange information with the other driver: their name, phone number, insurance company, policy number, driver's license number, and license plate. But here's critical advice. Be polite, but guard your words carefully. Don't apologize. Don't say something like, "Oh, I'm sorry, it was my fault," or don't speculate about what happened. Even saying "I'm sorry" can be interpreted as admitting fault. Why does this matter? Kentucky follows a pure comparative fault system, as Indiana is also comparative fault. If you're found to be even 1% at fault, your compensation gets reduced by that percentage. In Indiana, if you're more than 50% at fault, you may not recover anything at all. So just stick to exchanging information and let the evidence speak for itself. Step 2, seek medical attention immediately, even if you feel fine. This is the first step most people skip, and often it's one of the most damaging mistakes for both your health and your case. Even if you feel completely fine, you need to see a doctor or go to the emergency room as soon as possible after the accident. And here's why this is absolutely critical. Many serious injuries don't show immediate symptoms. Whiplash, herniated disc, concussions, internal injuries, traumatic brain injuries. All these injuries can take hours or even days to manifest. But here's the other reason this matters for your case. Insurance companies use delayed medical treatment as a weapon against you. If you wait several days or weeks to see a doctor, the insurance adjuster will argue, "Well, your injuries can't be that serious." They'll say, "If you were really hurt, you would have gone to the hospital right away. You must have been injured doing something else after the accident." Don't give them that ammunition. When you see a doctor, be completely honest and thorough about your symptoms. Don't downplay your pain or discomfort, like telling them that everything is okay, but tell them about all of your aches and pains and soreness, even if it's a headache or other symptoms. What you tell your doctor gets documented in your medical records, and those records become evidence in your case. If you don't report a symptom to your doctor, the insurance company will argue it didn't exist or wasn't caused by the accident, and keep going to all of your follow-up appointments. If your doctor refers you to a specialist or physical therapy, then go. If you skip your appointments or stop treatment early, the insurance company will argue you must not have been that injured. Follow your doctor's orders completely and document everything. Step 3, report to your insurance, but never talk to the other driver's insurance. You're required under Kentucky law and your insurance policy to report the accident to your insurance company promptly, but you need to be strategic about how you do this. When you call your insurance company, provide the basic facts: date, time, location, the other driver's information, and that you're seeking medical attention. Answer their questions honestly, but keep your answers brief and factual. Here's what you should not do. Do not give a detailed recorded statement without consulting an attorney first. Don't speculate about your injuries or say things like, "I feel fine," when you haven't even been to a doctor or being evaluated yet. Do not accept any settlement offer on the spot, no matter how reasonable it sounds. And absolutely do not sign any medical releases or settlement documents without having an attorney review them first. Remember, even your own insurance company is in the business of trying to minimize payouts. Now, here's where people get burned. Within a day or two of the accident, you're likely to get a call from the other driver's insurance company. The adjuster may sound friendly, sympathetic, eager to help you out. They might even offer you a quick settlement to cover your repairs or medical bills. Do not talk to them. Do not give them a statement. Don't answer their questions. Their job is not to help you, but it's to pay you as little as possible. They're trained to ask questions designed to trap you. They might ask, "How are you feeling?" If you say, "Oh, I'm okay," then they document that and use it to deny your injury claim. They might ask you to describe the accident, and they'll twist your words around to make it sound like you were at fault. Politely decline. You can say, "I'm not comfortable giving a statement. Please direct all communication to my attorney." If you don't have an attorney yet, simply say, "I'm still evaluating my situation and I'm not giving statements at this time." Step 4, keep detailed records on every single expense and impact from the moment the accident happens until forward, because you need to be meticulous about documentation. That's what separates a strong case from a weak one. Keep everything in a dedicated file. This includes medical records, bills, hospital visits, doctor appointments, physical therapy sessions, diagnostic tests like x-rays, MRIs, prescription receipts, over-the-counter medications that you bought for pain, car repairs, invoices, rental receipts, pay stubs showing lost wages, documentation of missed work, out-of-pocket expenses, even rides to medical appointments, and photos of your injuries as they heal. Also, keep a daily journal. Write down how you're feeling each day, what activities you can't do anymore, and how the injuries have affected your daily life, your sleep, your work, your family time. This creates a clear record of your pain and suffering, which is often the largest component of your compensation. Why is this so important? Because the insurance company will challenge everything. They'll question every medical bill, every day of missed work, and every expense. If you can't prove it with documentation, they won't pay for it. I've seen people leave tens of thousands of dollars on the table simply because they didn't keep good records. Also, keep copies of all correspondence with insurance companies. Every letter, email, notes from phone calls, including the date, time, and what was discussed. This creates a paper trail that protects you if they tried to deny something they previously acknowledged. Step 5, consult with a personal injury attorney before making any decision. Here's the reality that most people don't understand. Insurance companies have entire teams of lawyers, adjusters, and investigators whose only job is to minimize what they pay you. They know the law inside and out. They know every tactic to pressure you into accepting far less than your case is worth, and they're counting on you for not knowing your rights. When you're recovering from injuries, dealing with medical bills, missed work, and trying to get your car repaired, you're at your most vulnerable. That's exactly when the insurance company will push hardest for you to settle quickly for a low-ball offer. A qualified personal injury attorney levels the playing field. We investigate your accident thoroughly, gather the evidence, handle all communication with the insurance companies so they can't trap you with trick questions, and accurately calculate the full value of your case, including future medical expenses and long-term impacts. Negotiate aggressively for a fair settlement, and if necessary, take your case to trial. And here's something most people don't realize. Studies consistently show that accident victims who hire attorneys recover significantly more compensation than those who try to handle it themselves, even after attorney's fees are paid. That's because we know how to build strong cases, and we know what your case is actually worth. My firm works on a contingency fee basis. That means you don't pay any attorney's fees unless we recover compensation for you. There's no upfront cost, no hourly billing, no financial risk to getting professional legal help. We only get paid if you get paid. And here's the truth. You get one shot at this. Once you settle your case and sign that release, it's over. You can't come back later if your injuries turn out to be worse than you thought or if complications develop. The insurance companies know this, which is why they pressure you to settle quickly before you understand the full extent of your injuries. In both Indiana and Kentucky, there are time deadlines to file a claim for personal injury. However, I will say that I've always told people the sooner we get involved, the better job we can do, because evidence disappears, witnesses' memories fade, the insurance company uses time as a weapon, hoping you'll give up or accept whatever their offer out of frustration. So don't wait. The sooner you consult with an attorney, the stronger your case will be. If you've been injured in a car accident in Kentucky or Southern Indiana, call me at 502-222-2222 for a free case evaluation. Don't try to face the insurance company alone. We'll review your situation, answer your questions, and help you understand exactly what your case is worth and what your options are. Remember, you can count on the Colonel. And speaking of what your case is worth, that's exactly what I will cover in my next video. Watch it now and learn how car accident settlements are actually calculated in Kentucky and Indiana and what factors can substantially increase your compensation.